Welcome one and all to this meeting. It's myself and Mark from LPC Law discussing the Renters Reform Bill. Okay, just Mark and I are going to take this between us, but I'll kick off by basically saying that hopefully all of you saw the white paper that came out last year, a fairer private rented sector, which we had a lot on our website, and also we did a response to it, and basically most of what's come out in the actual bill has been pretty much everything that was in the white paper itself. There's one thing which is missing, which we're not at all surprised about, which is that they were talking about lifetime deposits in the white paper. Nobody understood what a lifetime deposit is, including the government. So they did talk about this a few years ago, and then it seemed to get quietly dropped. We were very, very surprised to see it back in the white paper. We're not surprised to see it not in the bill. So, anyway, I just want to mention, by the way, we are recording this for, so we'll send it all to you later on. If we take questions, if your screen will show on the recording. If you don't want that, just turn your camera off when you ask a question. So it's not a problem. Right, I'm just going to briefly go, so I'm still bringing people in. I'm just going to quickly go through the matters which are in the actual bill, and then we'll go through them, take them in a bit more detail. So the main thing is loss of Section 21, use of periodic tenancies, 2 months notice by tenants, no special treatments for students or landlords, a property portal, new property ombudsman, cannot reasonably refuse requests for pets, cannot refuse families, call to follow the decent home standard. Let's go on to this page. Come on. All rent increases will have to go through via a Section 13 notice, which can be appealed. They're going to review the course explained in the eviction process. And they're now it was actually 32. I counted them last night. Sad, isn't it? There's 32 new ground 32 grounds for Section 8. And then more ASB grounds. So we'll go through in a little bit more detail. Oh, sorry, one more ground there. Able to sell and move in. Just to make you aware that we are putting together a fact sheet on this, which is more or less finished. We will send that out with the weekly e-news when we send out next Tuesday morning. Hopefully you all get that. So you will see that, and there'll be a link on there to get to the weekly e-news. If you don't get it, or if you're not a member or whatever, then please do drop us an email, and we can send it out to you separately. So the email is normal. It'll come up at the end anyway, but is info@iHowz.uk. So go on to discuss this in a little bit more detail. I'm just going to point out to you that Mark and I are probably going to be using probably quite a lot, simply because this is a bill. And the point about a bill is it goes through Parliament, is discussed and argued about, etc., etc. And at stages, part of the bits in the bill can get amended. And in fact, Michael Gove made some announcements, I think yesterday, which has already amendments to it. It's not even started its progress yet, so it's going to be a bit contentious. So do bear with us when we say we believe it's going to be such and such. I also have to say to you, and Mark is going to cover this at the very end, but the actual bill itself is only something like 87 pages, which is not very much. The reason being is that they're dealing with an awful lot of it through what's called secondary legislation. And that's really, really important. And I say Mark will deal with that at the end. Right, the first two things we want to talk about are that the Section 21 will be stopped. So you will not be able to use it. Mark will come in a moment and describe what can happen if you've got a Section 21 ongoing at the time, but you can certainly use them at the moment, and you can use them up to the changes come in. The main other thing is that there'll only be periodic tenancies. So whereas most of you probably do a fixed term, and by the way, there's no legal reason to do a fixed term at the moment. It's just it makes a lot of sense to do a fixed term and then go on to a periodic. So those of you that have been doing fixed terms, which I'm sure will be most of you, you won't be able to do that in the future. And when this comes in, after it comes in, after 12 months, we're led to understand all existing tenancies will change to be periodic. Now, that's probably not too much of a problem, because if you do, say, a 6 or even a 12-month tenancy agreement, fixed term, they're talking about delaying this by 12 months anyway, and then when they do bring it in, most of the fixed terms will have dropped off. So, I don't think it's going to be too much of a problem. The periodic tenancies is a particular problem for student landlords, because it does drive rather a coach and horses through their particular model, in as much as that student landlords tend to rely on starting an agreement on a particular date on the basis that the previous tenants have either vacated or they're going to roll over into the following year. And basically, we've been saying to government, well, that's been a model that's been working for many, many years, and you are in danger of mucking it up. And in fact, talking to my colleagues in Scotland, they're less worried. They've had this in Scotland for the last 2 or 3 years, something like that. And they've managed without the Section 21. It's been a real nuisance and has caused more homelessness, which is what we believe. But the big problem has been periodic tenancies for student landlords, because what's called the PBSA, which is the purpose-built student accommodation, is obvious, wasn't it? Yes. So purpose-built student accommodation will be exempt from some of this. Now, this is where the announcement made by, well, it's not an announcement, it was just like all politicians do. It was a rumor mill. They've got round purpose-built by giving a special ground which allows a purpose-built student landlord to evict a student at the end of the tenancy. So, which is rather peculiar, because you don't have an end, because it's an assured tenancy with no end to it. There is talk about extending that right to private rental landlords, but this was an announcement, a piece in the Telegraph. So we wait to see. We wait to see what happens on that. And then the last 2 things I want to say on this before I hand over to Mark is that all statements must be written, that therefore will be the agreement as well. I'm going to call it an AST. I just know I'm going to call it an AST. It will not be an AST, but I'm bound to call it that. So it'll be an assured tenancy. So all tenancy agreements will have to be written, which I think is thoroughly sensible, because, well, lawyers, and I'm sure Mark will have a comment on this one, hate oral agreements, because you can't prove anything one way or t'other. There was some suggestion, and again, I would be interested in Mark's comments on this one, on the use of a model tenancy. What I mean by that is they keep talking about having to use approved forms. They don't appear to be making an exception for the tenancy agreement. They did bring out a model. It is an AST. They brought out a model AST several years ago, and it's enormous. Last time I looked, it's 45 pages. So it's going to be interesting to see on there. And then the last bit on this is that this is really important. The tenant can give 2 months' notice at any time. So they can move in and on the second day give you 2 months' notice. That is a particular problem for student landlords. Mark, sorry, I muted you by mistake. So Mark, do you just want to come in and just comment on some of that?
Yes, of course. So I think hopefully everyone can hear me all right. So I think clearly this is a wide-reaching change to the landscape for landlords. I think just to pick up on a couple of those points, there is some scope, and Peter's quite right, talking about we don't really know on a lot of these points how it is actually going to end up, because first of all, the bill is still progressing through Parliament. It isn't yet final. And secondly, a lot of these points are subject to the government being able to change the law or add new law by way of secondary legislation at a later point. So that also applies, for example, to the model tenancy aspect. There is discussion ahead preceding this bill to say that there would be expected for the landlord to provide a statement, what's called a statement of terms and other information. In essence, the landlord would be required to give the tenant a statement of the relevant terms before the start of the tenancy. Now, obviously, it is very helpful for lawyers to know in writing, you've got something in contract. If you go into a store, you want to walk out, make sure you've got a receipt. So you know you've got some proof of what you actually agreed to pay, for example. It's the same thing for a tenancy agreement. We want to make sure the first thing we'd ask if you came to us is to say, do you have a copy of the tenancy agreement? So we know what was agreed between the parties. So that's sensible. And it is sensible to a certain extent if that does come in, if there is some clarity about or a kind of a model tenancy agreement, because many landlords, I'm sure you've fallen into this, you may have fallen into this trap of using a pro forma tenancy agreement, and then it may come to court and the judge comments or the other side picks up on some inconsistency or some issue with it. If there is a model tenancy agreement, then that may be able to provide some assistance. But the point is, this isn't yet final. If it does come in, it would be set out in this secondary legislation, in regulations, and we don't know how that's going to be provided. And it does also dovetail with some of the other points I'll come on to, which relate to the so-called property portal, which suggests that it's through this portal that landlords would both access information, including this model tenancy, and provide that information to the tenant. But as it stands, we don't really, it's just not clear what the requirements are going to be regarding that, apart from the suggestion that it should come in.
Okay. Do you want me to go on to the next slide, which is about...
I think so, yeah.
There you go.
So eviction. So, I mean, this is the kind of, I suppose this is on one view what the hope is that it doesn't get to this stage, but unfortunately you always have to consider as a landlord that it might. And so it is critically important to be aware of what the landscape is what it is currently and what it's going to change to. So I'll focus on what it's going to change to. So the first point is the property ombudsman. Now, there is currently a property ombudsman, but only social housing tenants have access to it. So in essence, the proposals are that there's going to be a single government-approved ombudsman covering all private landlords who rent out property, regardless of whether they use an agent. Now, the purpose of that is, in essence, to resolve disputes swiftly without having to resort to court proceedings, and also, in essence, issue support and guidance to address, to assist tenants, to assist landlords. Now, the concern, I suppose, would be is that this ombudsman would have the power, as indeed ombudsmen do in other sectors, to make final decisions which would be binding on landlords. And the government, as it stands, has reserved the right to impose a right to enforce those orders through the court. So there is the implication or the suggestion that the ombudsman would have some teeth to bite. Now, the concern is also that, I suppose, that if the ombudsman is in place, then that can be used as a delaying tactic by tenants to, in essence, slow down the eviction process. So that is a potential concern, but the courts, as it stands, will still be the ultimate arbiter, subject to further regulations imposed by the government. Another concern, and something just to note, is that and the current proposals, just in terms of what the ombudsman could require the landlord to do, include, and these are just proposals, but something to think about, to require the landlord to issue an apology, provide information, take remedial action, or pay compensation up to £25,000. So quite clearly, there's a sliding scale there of action from something which you might not want to do in terms of giving an apology to something you'd certainly not want to do, which is compensation up to 25,000. And there is also the potential for potentially a power to impose a banning order for landlords who are deemed to be repeat offenders. So again, a suggestion that this ombudsman might actually have some teeth. But to turn to the second point on the slide, promised court changes. Now, this is something which the government, unfortunately, the courts as it stands in a number of sectors, but in particular in the civil sector, as well as the criminal sector, to be fair, the courts are not acting very efficiently or progressing cases very efficiently. There's a number of issues with that. I mean, there's delays in the court processes are widely known and widely recognized. And where that would, you become aware of that is if you sought to issue a claim for possession, you might only get a first court hearing within, say, 8 weeks. But then if it's adjourned for any reason, it might not come back for several more months. Now, what is the government planning and what does this bill do to address that? The simple matter is not very much, apart from, as far as I can tell, apart from a lot of buzzwords about digital courts. The suggestion is that if the ombudsman is brought in, then that could potentially free up a bit more time for the courts to deal with more substantial issues. In terms of the proposals the government has to speed up matters in the courts, they're talking about increasing county court bailiff capacity, so the actual process of eviction in terms of instructing bailiffs, removing paper-based processes. This is the digital courts touchstone, which we shall see. Courts have been notoriously reluctant to change the way, they're rather conservative with a small c, if I can put it in those terms, in terms of changing their processes to keep with the times. Digitally, just using, so for example, making more reliance upon digital Section 8 notices, bringing claims digitally, it might speed things up, but I don't think that really is the main issue in terms of court processing times. Frankly, it seems just to be court capacity, judges actually being available to hear these cases. A further proposal is using that there are trials ongoing at the minute to use what's called the first tier tribunal, which deals with property cases, to deal with more specialist cases. And again, that might free up some capacity to the courts, but unfortunately, it looks like this bill is not going to be a panacea. As a final aspect within this, mediation, and potentially there's a possibility of, in essence, enforced mediation between the parties, like the landlord and the tenant. There are currently pilot schemes ongoing, including one run by the government. The government runs its rental mediation scheme. However, the government is considering embedding this mediation within the court process. So in essence, making it compulsory for the parties to engage in it. The concern, again, as with a number of things I've said already, is that this, in essence, permits the tenant from delaying further. By, in essence, if the tenant agrees to mediation, the landlord is expected also to agree, and there's another months before you actually get the court listing and it actually comes back for a final hearing. Just as a final point, I just want to touch in terms of the court's actions. I just want to touch on the possibility of the risks to landlords regarding unlawful eviction. As it stands, it's something to be concerned about just when dealing with eviction from properties. The point is, it can be unintentionally done. And you have to be very careful when a tenant is in the process of wanting to give up possession of the property. You always have to be very careful before you re-enter the premises. And that's why landlords often have to wait for a final court order and indeed for bailiffs to be instructed. The current situation is that if you, for example, fall slightly foul of that law in terms of unlawful eviction, if, say, there's still belongings of the tenant at the property when you re-enter and the full court processes haven't been followed, then there is the risk of prosecution currently in the magistrates court. That is generally, can often just amount to a slap on the wrist, but it is a cumbersome process. It doesn't always go to its conclusion. Now they're suggesting, and there's much greater role throughout this bill for local authorities, with local authorities now introducing civil penalties for unlawful eviction as an alternative to prosecution. So that would be, instead of being prosecuted, it would be a fine, but a maximum fine of up to £30,000. So in essence, it's something to be even more careful about regarding eviction from the premises. But to move on, I've talked enough about evictions, and we can obviously come back if there's any questions at the end. But in terms of Section 8, this in essence is the new notice seeking possession. And I should also note, just a preliminary before we get into the grounds, in terms of you may be aware, if you had gone through the process yourself, in terms of there are requirements relating to the deposit. For if you take a deposit from a tenant, that firstly that needs to be protected in a registered scheme, and also you need to provide information to a tenant regarding where it's protected and information about yourself as a landlord. Now, as it stands, regarding Section 8, if you fail to take those steps, if you fail to protect it properly, and it can be a simple matter of, anyway, if you fail to protect it properly, that would prevent you from serving or relying upon a Section 21 notice, this no fault notice, which is now gone, but it wouldn't impact a Section 8 notice. As it stands, though, with this bill, they are now bringing in the obligations to ensure that the deposit is protected and that the requirements are being complied with to all grounds for possession. So aside from some antisocial behavior grounds. So now you have to be an extra step. You have to be, when you're bringing a claim brought on Section 8, so for grounds for possession, for pretty much all the grounds, you need to make sure that the deposit is either protected in a registered scheme or has been returned if it wasn't properly protected, and that the required information has, at least before service of the notice, Section 8 notice, has been sent to the tenant. Anyway, let's crack on with the Section 8 grounds themselves. So the first point is, as is up on the screen at the minute, there are three broad kind of or main grounds that you might seek to rely upon. The first deals with arrears. Various grounds deal with arrears. The current legislation is grounds 8, 10, and 11, which is what they're referred to. The most important one as it stands is ground 8. And these grounds aren't changing, but for one aspect, which is that as it stands, the notice period for those grounds is 2 weeks. That's now increased to 4 weeks. So you need to give 4 weeks notice for a tenant who's in arrears. As it stands, the most important ground is ground 8. That's what's known as a mandatory ground. And that basically means that if this court is satisfied that ground is made out, that there's very little that the court can do, or make a possession order, and the tenant can't really delay that much beyond, can't delay that beyond 14 days in the first instance, and certainly beyond 42 days. That's it, they're done. So ground 8 stays, but the notice period increases to 4 weeks. There is a new ground which is attempting to compensate, in essence, for the loss of Section 21, which is, it's called ground 8A. It's the 3 strikes and you're out ground, basically. It is whether the tenant has, over a 3-year period, fallen into arrears of at least 2 months on 3 separate occasions. So that, in essence, means if they have fallen into arrears of at least 2 months, then reduce them below the 2-month threshold, and then fallen into arrears again, that's 2, reduce them below, and then fallen into arrears again, that's 3. You're 3 strikes and you're done within 3 years. So it's a new ground, but in essence, it supplements the arrears-based grounds. The second, or the next slide should hopefully deal with the antisocial behavior grounds. There's 2 main grounds that are relied upon. There's a mandatory ground, which is ground 7A, that's where, and that remains unchanged, and that's where the tenant is, aside from the notice period, that's where the tenant is, as it says, convicted of a criminal offence, breached an IPNA, which is an injunction to prevent nuisance and annoyance, breached a criminal behaviour order, convicted of causing noise nuisance. There's also a discretionary ground 14 that's been very slightly amended to now it's yes, it's changed from likely to cause nuisance or annoyance to capable of causing nuisance or annoyance, which may be the slightest amendment of so little effect in statutory history. Obviously, if something's likely, or if behaviour is likely to cause nuisance or annoyance, one would expect that it's also capable of causing nuisance or annoyance, but there we go. For both of those grounds, there is now a lower notice period. So the possession order, if the only grounds are grounds 7A and 14, so the antisocial behaviour grounds, the possession order can take effect within 14 days of the date of service of the Section 8 notice. So in essence, it's slightly easier to, or a slightly speedier process if that ground or those grounds are made out, and the test in essence is up on the screen. The third main kind of group of grounds for possession relate to either sale or of the property by the landlord, or occupation, i.e. the landlord wants to occupy the premises themselves, or the landlord wants to redevelop the property. As it stands, ground 1 deals with the landlord or a close family member wishes to move into the property as their principal or family home. So this is where you've previously lived, as it stands, you've previously lived in the property, you want to move back in, so you would like the tenant to leave, please. This is amended, so it can now, is that it can only be by notice served after 6 months, so not within 6 months of the start of the tenancy. As it currently stands, you are required to have served notice to the tenant before the tenancy starts that you can rely upon this ground. So in essence, you specify somewhere in the tenancy agreement, or you otherwise before the tenancy starts, you say to the tenant, I want to have the ability to rely upon ground 1, i.e. when I need the property back, you have to leave. That's now no longer a requirement. So if you've currently got a tenancy agreement that doesn't have that ground, and so you wouldn't be able to rely upon it, that's now gone, or will be going. In terms of, so it applies to the landlord or their close family member. Close family member is basically given the definition that you'd expect: spouse, civil partner, someone you live with as if you're married to them, or any close family and kind of parent, grandparent, sibling, child, grandchild. The one thing to be important to be aware of for this one, though, and also the other grounds under this, mandatory grounds under this aspect, is that if the tenant leaves under one of these, so selling, development or redevelopment, if the tenant leaves under this, you can't relet the property or advertise the property for the next 3 months. If you do, you're liable to a financial penalty imposed by the local authority of up to £5,000 or prosecution as a criminal offence. So if you ask for the tenant to leave because you want the property to live in the property again or redevelop it, and then you let it back out immediately, you're opening yourself up to a penalty. I'll go through the other grounds, but they're very similar. In essence, it's ground 1A is if the landlord wishes to sell the property, so a similar situation, but instead of occupying it, you want to sell it. Again, you can't relet it within 3 months. So you've got 3 months to, if you end up changing your mind. And then ground 6 and 6A deal with redevelopment and also compliance with enforcement action. For example, so you either want to redevelop the property or you have to comply. So let's say an improvement notice is served, or for example, number of occupants, so the council informs you that the number of occupants in the property is too high. You can rely upon ground 6A, because otherwise you'd be in a catch-22 situation of being unable to evict the tenants, but the council's not letting the tenancies continue. So that's a brief run through of the main grounds for possession as it currently stands, and also what it's now changing to. I think, unless there's any points you'd like to pick up on, Peter, I think.
No, right. What we're going to do is we'll take questions at the end. We've got quite a few coming in, so we'll pick them all up at the end and try and sort of roll them together, as it were. So I just want to briefly mention about rent changes. I haven't put rent going up because it could go down, of course. So it's a rent review clause. The courts have never really liked rent review clauses in ASTs, and under this bill, they're going anyway. You will not be allowed to put a rent review clause in your agreement. Instead, you will have to use a Section 13 notice, and you can only do a Section 13 notice a minimum of annually. The tenant has the ability, and we're not aware this is going to change, to appeal to the first tier tribunal. So if they go to the first tier tribunal, the tribunal will basically go to what we used to call the rent officer, the VOA, and they will find out the market rent. And if you're at or below the market rent, you're absolutely fine. Now, there have been cases in the past, and I don't know if this will continue, where if you're well below the market rent, the FTT could actually order the rent to go up to the market rent. So that could end up biting the tenant if they went that route. But there was some rumours about stopping that particular part. So we wait to see. So that's, I'm assuming that we've also had the situation in the past that you could do a rent increase by mutual consent. In other words, you both agree it and you both sign a letter to say the new rent will be X pounds. I can see no reason why that won't be continuing.
So as I understand it, it's now not possible. Well, so any rent review clause in a tenancy agreement is of no effect. Yeah.
So, but if there's a mutual agreement afterwards, not in the agreement,
that's something I might need to look into a bit further before I can give definitive advice on it, and we'll see how the bill shapes out. But I think ultimately, if you have an agreement reached with the tenant and they're paying you the money, then I think obviously you'd rely upon that. So yeah.
Right. Okay. So Mark, you're going to pick up on registration.
Yes, indeed. So there's a number of aspects here. So I've already touched on the property ombudsman aspect, but I can go back through that. But the first matter deals with this so-called property portal. So that was what was trailed in the white paper. I think as it's coming out, it's going to be referred to along the lines of a private rented sector database. It's a digital portal. The purpose of which is to enable landlords, on the face of it, to understand their obligations, to find their way through the kind of the myriad regulations and issues that can arise, and also to help tenants make better decisions when signing a tenancy agreement. So you'll be aware that at present, the kind of closest that we get to this is the requirement on a landlord to serve a copy of the How to Rent guide on the tenant at the outset of the tenancy. I suppose this is in essence trying to kind of digitize and go much further in the process. It is going to, in terms of providing tenants with information about the landlord's identity, for example, and what needs to be complied with in terms of the legislative requirements. It is going to be compulsory, and I should say this is potential at this stance. It is not necessarily coming in, but it is potential. It's compulsory as it's on the current plans for all landlords and prospective landlords. It would, in essence, be public as well, subject to regulations. So entries about this would be public, which is something to bear in mind. And again, another civil penalties point. If you don't fail to comply by, for example, I suppose, not dealing through the portal, there would be an additional civil penalty of up to £30,000. That dovetails also with the redress scheme, which again is potential, but would be compulsory for all landlords or potential landlords to be a member of. And again, failure to be a member of this redress scheme would or potentially result in a civil penalty of up to £5,000 or criminal offence with a penalty of up to £30,000. What that scheme would do is, in essence, provide for enforceability. It would provide for independent investigation of a tenant or prospective tenant complaint, and the decisions would be enforceable as if by a court order. There's a number of different schemes here, and it's not entirely clear how it's all been thought out. It is as it stands, especially taken with the property ombudsman, and also I should say this, the final point, the potential to integrate the so-called rogue landlords database. I should say, as it stands, local councils are required to record landlords who are issued with banning orders. So that's quite a limited area. That's where they've committed an offence, in essence. So there is currently a database of rogue landlords and property agents. And currently, if an individual is served with 2 or more civil penalty notices within a 12-month period, they would be entered onto that database. The current proposed extension regarding this rogue landlords database is to extend that to include all offences committed by landlords, not just banning orders, and make them publicly available, and to also lower the threshold to cover all civil penalties. So the upshot of taking all these aspects together, and on top of that, we've got then the ombudsman as well, which would have the power, as we've discussed, to impose banning orders, pay order compensation up to £25,000, right to enforce decisions through the court if there's insufficient compliance, all those aspects. In essence, we end up in a situation where we're not very far away from a database of landlords, public database of landlords, potentially searchable by tenants. Now, we're not there yet, and we'll see how this, whether that proves to be or those aspects prove to be fatal to those parts of the bill as it stands, and the implication that, you know, clearly there's no appetite, as I understand it, in government to go the full hog and bring in a national database of landlords. But you can tell that from these various public and compulsory databases, we're getting rather close. So like I say, this is one of those things, aside from the ombudsman, which is coming in, it's one of those things to keep an eye out, and obviously I'm sure iHowz will provide in due course advice and assistance in terms of what the current state of play is, but something very much to bear in mind, given that the penalties for failing to comply with these are very high financially and potentially with criminal sanction.
Okay, right, thank you. And then the last few things we want to mention. This bit's not actually in the bill, but the government has, as it says there in quotes, will bring it forward at the earliest opportunity. So we're not clear whether that means they're going to add it to the bill or just do it as probably as a statutory instrument at some later stage, where you won't be able to have a ban. You won't be able to stop renting to families or children. This is basically advertising will be there'll be a blanket ban on that. Now, this isn't a lot different, quite frankly, because with this one and the next one, which is pets, so we'll cover both. Because the agreement you've got at the moment is a contract, you're subject to contract law, and so you can't have unfair terms in there, and you can't have you can't have blanket ban, particularly on benefits. Shelter have taken 2 agents to court in the last year or so, and they won both times. So it's quite definitely agents, and by extension, therefore, landlords cannot put in their advert no, as you used to say, DSS, but no benefits. And you certainly won't be able to do that for pets and for children, for families and children. Now, this thing about pets, what it says is that the tenant can request to keep a pet or pets, and the landlord cannot reasonably refuse the request. Now, as long as you've got a good reason, then you're fine. And one of the reasons that I would imagine it's currently isn't the case at the moment, I can't see this going away, is if your head lease does not allow you to have pets in that property, then the lease tends to trump the tenancy agreement. So that would be brought through as well. So I'd be interested in Mark's comments on that. And the last thing I just want to mention on this is there's been a lot of mutterings about pet insurance. I know Steve Cox on the line, so he'll probably shout at me for saying this, but the pet insurance as it stands at the moment isn't an awful lot of use to cover this, because it's great for covering things such as your prize Ming vase getting knocked over, but it won't cover the things that we all experience as landlords, which is the cat weeing in the corner or scratching or whatever. So as it stands at the moment, it won't cover that. Whether or not new insurance is brought in, we'll wait to see. If Steve, you want to make a comment on that, you're very welcome to do so. The other problem that we've got with any kind of insurance is, although you can insist on the tenants having pet insurance at day one, so in other words, no correct insurance, no tenancy agreement, and no keys, there's nothing stopping them cancelling that pet insurance immediately afterwards. And there's no way currently, and I do stress the currently, of making sure that they renew that pet insurance in 12 months' time. So again, this one's slightly fraught with problems. We are making the case to government to say, well, they're talking about amending the tenant fee bill, Tenant Fees Act, to allow for pet insurance. Well, we say, well, why can't you allow for a larger deposit where pets are involved? Already, if you can prove that the local rent would be higher if you're allowing for pets, then you can charge a higher rent. But only as long as you can prove that. If you went to the FTT to say that there are adverts there saying, let's keep the numbers easy because my brain can't cope with complicated numbers. But let's say without pets it's £100, with pets it's 110. Then that would be accepted. So have you got any comments on families and pets before we move on?
Yes. So I mean, in respect of families, like you say, Peter, that's not coming in just yet, but it looks like it will be similar to the pet situation, and whether they can, you cannot unreasonably refuse, and also by extension to benefits claimants as well. On the pets point, I saw a question float up there, and we will go to the questions at the end, but a question floated up there. What about exotic pets? Well, the interesting thing is the definition of a pet. A pet is defined in the Act. And lawyers obviously love a vaguely drafted clause. And what is defined as a pet, you may be interested to know, is an animal kept by a person mainly for A, personal interest, B, companionship, C, ornamental purposes, or any combination of those. So that's quite broad, to put it lightly. So you can potentially begin to see a spate of cases of tenants attempting to argue that their pet so and so is their pet because it's kept for ornamental purposes. In terms of the leasehold point, it is the case that if the lease forbids pets, then ultimately, in essence, then it wouldn't be unreasonable for the landlord to refuse. But there is an additional obligation on the lessee, on the landlord, in essence, who has a superior landlord, to at least request permission from their superior landlord. So if the superior landlord turns around and says, no, I'm not changing, I'm not allowing pets in, then that's fine. It's not unreasonable, but they have to ask. So that's an additional obligation.
Okay.
Yeah.
Right. Thank you very much. And then the last bit I wanted to cover is property standards. That there's call in the paper to follow the Decent Home Standard, which per se we've got no problems with. Where we do have the problem is that the Decent Home Standard, as it stands at the moment, is only applicable to social landlords. The proposal is to make that all landlords will have to follow a Decent Home Standard, but it's very vague. It's incredibly vague in places. As you can see on the last line on that, adequate heating. What does that mean? with the case of food preparation, adequate space to prepare food. Now, the likes of Mark love this sort of thing. That's how they earn their money, arguing in court what adequate means or what this means or what that means. I remember being in a court case, it was the Kumasami case in the Supreme Court, and we spent, or the judge and the barrister spent, must have been 25 minutes arguing about the difference between exterior to and exterior of. And it's, oh, for goodness sake. But that's how the likes of Mark earn their money. So we wouldn't begrudge that at all, would we? So the other thing to remember on the Decent Home Standard is the government did do a consultation on this. They're due to report on it. We hope that the report will come out before the bill, this bill we talk about, the Renters Reform Bill, becomes an act, if it does become an act. So we just wait to see. Otherwise, we're going to be left slightly in the lurch. Last thing I just want to mention on this, before I pass back to Mark, is we're also making the case that if a landlord has to be registered somehow or another, and those details will be known to the local authorities, certainly, and they have to follow the Decent Home Standard, then, and again, we don't know whether they're going to self-declare that they followed the Decent Home Standard, then where's the point in licensing? Because, you know, that's the statement's always been from local authorities that they're bringing a license to control rogue landlords, because we don't know who they are, well, they will in future, and to control indecent homes, if there's such a thing, well, in future, in theory, they'll all be decent. Now, we know that when you get licensing, an awful lot of landlords don't bother licensing. So, you know, we're going to have all sorts of problems with this as well. So this is, you know, unfortunately, this again is the decent landlords, the people who want to do the right things will do the right things. The rest will go below the radar, and we will be pushing government to say, you're saying you can, or local authorities certainly, to follow up on the bad landlords and do something with them. So I just wanted Mark to talk about the importance of secondary legislation, really.
Yes. So as I've been going through a lot of the kind of comments I've been making about various aspects and things that we are expecting to come in, are saying, and as indeed was flagged up at the outset, this is possibly going to come in, or this may come in. The point is that the bill, and if it's made an act, it provides for quite extensive and far-reaching powers for the government, as the government does in many other areas when they're bringing bills through Parliament, to in essence legislate after the fact, to bring in so-called secondary legislation, which allows them, rather than having to go through the tedious route of actually getting it approved by lawmakers in Parliament, that they can just issue regulations and they can bring new laws in. Now, that wouldn't be as an amendment to the Act as it's published. That would be in so-called statutory instruments, which far outnumber the actual legislation on the books in England and Wales. And so a lot of these additional measures which may come in, for example, the redress scheme, which has far-reaching implications upon landlords, financial penalties, for example, for failing to sign up to it, and of between £5,000 and £30,000. This emphasises the importance of keeping track of legal developments, because obviously failure to be aware of the law is no defence to it, or it's very unlikely that's how it's going to be. It's going to come out from the government. So the importance is, as has been mentioned, the bill is, and the act, if it's made an act of Parliament, is quite short on a number of these areas, but it simply provides a number of other aspects to look out for in these secondary instruments, in this secondary legislation, to see when these additional important aspects actually finally come in. So again, iHowz providing a great service in terms of keeping track of that.
Yeah, and really, I just want to stress the importance of statutory instruments, or SIs, in that Mark called them a way of speeding legislation through Parliament. I call it a backdoor method for government to get stuff in without it being inspected by MPs. So we do have to be careful on this one. And this government in particular have had a habit of bringing in legislation which is quite light and relying completely on statutory instruments for the law to be made. And we will attempt to keep an eye on statutory instruments and to make sure that we shout at MPs so it can be brought up in the House and debated. Basically, what happens is, I know this sounds a bit archaic, but literally a statutory instrument is printed, it is placed on a table in the House of Commons. Unless a certain number of MPs object to it, it'll just go through. It'll become law. So, and that number of MPs, only about 2 or 3, isn't it, Mark? It's not many. So,
indeed, yeah.
Need to check that, but it's only a small number of MPs, and we've got some friendly MPs who are willing to do that. But it's very much a case of keeping an eye on statutory instruments and making sure we get them checked out at the time. While Mark's moving off,
sorry,
go on to, don't worry, no problem. This is the timetable. The bits in green have already happened, in much as they published the bill and they did the first reading. Well, the first reading is very much a case of, there you go, chaps, that's it. Take it away and read it. And in some time in the future, we'll have a proper debate on it, which is the second reading. So everything that's happened thus far is just doesn't really mean anything, quite frankly. The second reading won't be at least for a couple of weeks, because as of, what's the date today? 24th. So as at tomorrow, the House of Commons recess for the spring break. So they're all going off for their jollies. So it won't get picked up again until they get back. We've had all sorts of different comments about when the second reading might happen, going from a couple of weeks' time through to about 3 or 4 months' time. We don't know. And it's very much a case of the leader of the House finding time for Parliament to actually put it down for several days. It's not something that will happen very quickly. We, in the meantime, are talking to MPs. We've got a group of MPs who are aware of our concerns with this bill. And I have to say that in general, we haven't got too many concerns with the bill. Where we've got the concerns, it tends to be with the loss of the Section 21, where even with the new antisocial behaviour wording, it's still it's got, I believe, again, I'll be interested in Mark's comments on this, it'll still be extremely difficult to evict someone under antisocial behaviour. Which is where Section 21 has been used in the past. So we've got various proposals on that. And the other real big concern we've got is with periodic tenancies. And I noticed a couple of questions about that. So just carry on what's going to happen. It'll then go to the committee. The committee there's a shadow committee to every department. So the departments put this out, it's called DLUC. There's a shadow DLUC committee. They're already gearing up. They're obviously already looking at it. They already took the white paper itself to task, and they have various people in front of them, including the Secretary of State and the Housing Minister at the time. So they will sort of basically repeat that, but a lot of it's been done already. But the committee will go through almost line by line. And that the second reading and the committee stage will be our principal time to be able to try and get any amendments brought in. The committee will make a report, and then that will go to a third reading, and then it'll go to the Lords. Now, if the Lords basically say, well, yeah, okay, we agree with all this in its entirety, off you go, then that'll be it. It'll go back to the House of Commons, and it'll go through for royal assent. If, as we anticipate, we've got a Lord actually who's going to table an amendment to the bill. He's already told us that. So if, say, for sake of argument, the Lords say, well, we don't agree with clause 37, whatever clause 37 is, we believe it should be this wording, it would go back to the House of Commons under what's commonly known as ping pong. So it'll go to and fro until between the pair of them, they can either agree on a common wording for, in my example, clause 37, or the House of Commons goes, tell you what, we've had enough of this, we're going to impose it. And then they can overrule the House of Lords, but it is there at the moment. Financial privileges is basically the government stating how it's all going to be paid for. So a lot of it, as Mark has already alluded to, the cost of registering will be borne by the landlords. That's been stated already. So it'll be basically all that there. Then it'll go through to royal assent, and then all the regulations will come out. But the only question I want to ask before we go on to a general discussion is, will a general election derail this bill? Because we've got to have a general election before December of next year. Can't do my arithmetic. That's what, 18 months time. It's going to take at least 12 months for this to go through the House of Commons. The very, very earliest we'll see this happening is April next year, and that's most unlikely. Again, I'll be interested to see what Mark thinks on this, but we'll wait and see. So it could be October of next year. We've had a question already about existing ASTs. Well, we've been told, again, unless this changes, that so let's say, for sake of argument, the bill becomes law next April, just for sake of argument. There is talk of a 6-month implementation period, which will take us to October. Then that's when everything will start to happen. But they're already saying that there'll be a 12-month period after that where existing ASTs will remain in place. So any Section 21s, etc., will remain valid unless they make it retrospective, which would be extremely unusual. It's very unusual to make it retrospective. But unless they do that, then so we've got plenty of time to sort all that sort of thing out before the whole thing goes live. And as I said, we will have a general election in that time almost certainly. And all I can say to you is, if you think life is bad for this kind of thing under the Conservative government, well, Labour are already muttering about it doesn't go far enough. You know, should there be rent regulation and rent freezes, etc. The last slide I want to put up before we put it up into general discussion is just to say to all of you, and you should have been doing this anyway, quite frankly, but it's really, really important that you do this in the future, is just to make sure you do your due diligence. Because even if you've got a void, if you've got an empty property, don't go rushing into offering to somebody, because if it all goes horribly wrong, it's going to cost you an awful lot more than that void period at the beginning. That's the situation now, and that's going to get worse because you do have the safety blanket of Section 21, and that will almost certainly go. So please do make sure you do full referencing. An awful lot of lawyers I've been talking to, and again, I'm interested to see what Mark thinks of this, but an awful lot of lawyers say, we would like every tenant to have a guarantor. Go with your gut instinct. When I've taken on tenants in the past and I've gone against my gut instinct, it's cost me. So your gut instinct, especially if you're an experienced landlord, really does matter. If you don't offer, don't give a reason, because you might end up giving a reason which turns out to be unlawful. So, you know, if you're not willing to offer, you're not willing to offer. Consider rent guarantee insurance. Steve, I know we'll be flying a flag on that one. Make sure you manage the property correctly, and always keep communication open. So often on our helpline, we get the situation that the line of communication is broken down, and it still just causes problems. So even if you've got the tenant from hell, then for goodness sake, make sure you keep that line of communication open and keep trying to keep talking to them. So that's the end of the slideshow as it stands. We're now going to go through the, let's have a look. I'm going to pick up the last one first, unfortunately. If there's an election before the bill comes to an act, we'll have to start again. Yes, because all bills are dropped on a new parliament. Now, they've got the ability. So, for instance, let's just say Labour get in and they say, right, we're going to pick this bill up again, but we're going to add substantial things to it. So, yes, it would start again. Someone had a very good point about, if I can find it somewhere. Someone said here, isn't there a statement that the tenant has the right to alter the premises? I presume you mean by that, Jeff, in the bill. So are you aware of something in the bill that says the tenant has the right to alter the premises, Mark?
Not as it stands. Not as it stands. However, there is the strong possibility, or that it could be extended. So the aspects about pets, families, that could be extended to, for example, tenant requests to redecorate, to hang pictures, change appliances, subject to making good when they leave. So somebody keep an eye out for.
Someone said
I'd actually seen that somewhere, that there was the option of the tenant altering the premises, but maybe I'm wrong. I thought I saw it.
I think it's as Mark has just said. So we wait to see. As we keep saying, it's a bill. It won't necessarily be the situation that everything you see comes in. So someone's made the point here about if you've got a license, you already need a written tenancy agreement. Yes, I agree. But the point is that if you've not got a licensed property, you don't at the moment need a written agreement. You could have an oral agreement. And I'm amazed how often we come across them, quite frankly. They nearly always tend to be where someone's letting to a friend, member of the family, business acquaintance or whatever. And we've always said to them, always have an agreement. Well, you're going to have an agreement. Is a model tenancy a template contract? Yes, it is. Yeah. Can the property ombudsman tell the tenant what to do as well as the landlord? Mark, do you want to come in on that one?
Yes. So as I understand it, they have the power to make a final decision, which would be binding on the landlord if it's accepted by the tenant. So I don't believe, unfortunately, I don't think I can confirm as it currently stands, but I think in essence, as it with most other ombudsmen, they are designed to protect the small player against the bigger player, so-called. And so I think it would appear to be more of a tenant-facing aspect. Now, obviously, if it goes on the matters, for example, disrepair of the property, then one could see that they may have some scope there to well, we'll see how it shakes out, but there may be some scope for them to be able to resolve those types of issues, for example, disrepair of the property. But as it stands, it looks like it's more so a binding on the landlord if the tenant accepts.
Yeah. The one I wanted to find was under the ASB clause of Section 8, would a police crime reference number be sufficient, or would you need to await a criminal conviction, which may take years? This is the bone of contention. Do you want to follow that one through, Mark? Because this is a really important one.
So mandatory ground, you need tenants being convicted of a criminal offence. So no, it wouldn't cover it. Breached an injunction to prevent nuisance. Again, that's fairly serious and unlikely in that case. Breached a criminal behaviour order. Again, same thing. Or convicted of causing noise nuisance. So you need either a breach of an injunction or conviction. So mandatory 7A, very unlikely and in essence, very serious cases. Discretionary is likely to cause nuisance or annoyance. Well, now capable of causing nuisance or annoyance. That is broader, clearly. Nuisance has a defined legal term. It is a defined legal term. One-off actions are unlikely to be sufficient. You need to, in essence, in most cases, there needs to be an unreasonable and substantial interference with the use and enjoyment of your property, for example. And it must, in essence, usually be serious. The fact it's discretionary means the courts retain a significant degree of control over that. So that you always, for a discretionary ground, mandatory, if it's made out, it's done. The court has to order it. If it's discretionary, the judge will always then ask themselves, is it reasonable, regardless of whether that's made out, is it reasonable to make a possession order? So you have, in any event, even if you cross the boundary in persuading the judge that, that it amounts to a nuisance, for example, then the question is, the judge will still be saying, and quite often judges can fall down on the side of tenants, unfortunately.
Yes, yeah, that does often happen, and a particular problem that Mark and I agree on is that for many years it's been suggested that there should be specialist housing courts, because the problem we've got is that it currently goes to a normal civil court, and with the best will in the world, the judges or deputy judges who sit there are supposed to know everything about everything, and they can't. And so if you come up against a judge who's not dealt with housing before, he or she is going to be basically looking up in their book, if they've got the time or if they can be bothered, and they're going to be giving their best advice, and that can be wrong. Obviously, you can appeal it, but that all takes time. Now, this thing about antisocial behaviour is a real problem. I've got to be careful what I say here because this is a real case. But we assisted someone who had a situation where they were letting HMO, individual rooms, individual agreements, and one of the tenants on the first floor sexually assaulted a lady on the ground floor, and he went to court. And all the court said was the man had to stay away from the woman, and it was not enough grounds for eviction. That's just appalling, absolutely appalling. The court should have shut that person out immediately. So the only way we could deal with that was on a Section 21. But almost certainly, if it had gone to appeal, then a proper judge, and I'm sorry to be rude about judges, but I say it's not their fault. They're expected to know everything about everything. A housing court would have solved that particular problem. So, you know, ASB is a real problem. Right, this is a good one. The sharing tenancy. Right. So this is basically, as the law stands at the moment, if you've got if you've got more than one tenant in a property, well, it's an HMO or not. An HMO is where they're not related. If they're related, it's a family, it's fine. But if one of the tenants gives notice, that gives notice for all. Now, this can cause this may well cause a problem in the future for periodic tenancies for students, where if you give an agreement for all the students on one agreement, and then one of them decides they want to leave in February or March, which can often happen, if they give notice, technically that ends the agreement for all of them, which means that the student tenant's going to lose out because they've got a lot of uncertainty, perhaps at the time they're doing their exams. Now, we don't know this next one, but we suspect that the National Union of Students, who have basically welcomed this bill, will be advising them student tenants to say, don't sign one agreement for all of you, sign individual room agreements. Then if Fred Bloggs in room 3 wishes to leave, then they can do so. But there'll be nothing stopping the landlord bringing whoever they want into that room. So again, I know of a landlord, they only let to Muslim women, and therefore they respect their views, and they're very careful about who they bring into that property. If it's a disreputable landlord, they could bring a man into that individual room, which would mean the other Muslim woman in this example would have to leave immediately because they wouldn't be able to put up with that. So it is open to all sorts of problems. We've got one here for student tenancies where tenancy created in December, January, commencement in July. One, how can you do this if you can't be certain of the intentions for your current tenants? You can't. And this has been raised several times. Can tenants end the tenancy before it commences? Well, no, because you can't you can't end a contract before it started. So no, you can't do that. Also, PBSA purpose-built have different rules. Is this an unfair advantage? Yes, quite definitely. And I was talking to my equivalent in Scotland, and he said they've coped with the Section 21 going. It's been difficult because this came in 2 or 3 years ago. And so they have coped with the Section 21 going. But the thing they've not been able to cope with is this periodic tenancy and the ability to give notice. And it's just driven I can't even say it, anyway, driven a right problem right through the middle of the private rented market. Now, as already mentioned, Michael Gove has been making noises about changing it so that all student landlords can give the notice to get rid of tenants at the end. I'm not a student landlord, but I understand from student landlords getting tenants to leave at the end of the term tends not to be a problem. You might get the odd one who wants to stay on, but it tends not to be a problem. What can be a problem is them wanting to leave early because they've dropped out of that course, they've taken their exams early, whatever the reason. And this is going to give void periods to student landlords, and the only way of covering that is by putting the rent up. So trust me, we are banging the drum on this one. We really are. We've got a tax question now. I can't take a tax question because I'm not a tax expert. but just be careful about whatever your stated rent is, then that's what you can get taxed on. So if you've got arrears and you don't deal with it correctly with the taxman, you might well end up getting taxed on what the rent should have been. So, but I'm not going to go any further on that because I'm not a tax expert and I'll get shouted at if I do that. We've got one at the bottom, which is if your flat can't be brought up to EPC standard, is that grounds to evict? It depends if you're going to have to do work where you need vacant possession. If you need vacant possession of the property, that's called refurbishment, then that will be a ground. But the fact that you can't, if the flat cannot be brought up to EPC standard, that's not a problem at the moment because you can claim an exemption. And once you've claimed an exemption, then you can carry on letting the property. So that should be all right in the future. But I have to say to you as well, this is a different subject, but we were sort of informally advised that this government is basically kicking management energy efficiency standards and UEPCs into the long grass. That there was a consultation which ended 2 years ago. They expect the report, only the report, to come out at the end of this year. That'll be 3 years after the consultation. That will give them absolutely no time to bring in anything in this parliament. Absolutely no time at all. So the general feeling is they're basically leaving energy efficiency and MEES, etc., to the next parliament. Now, I think we've answered most of the questions. We normally allocate an hour, but we've gone over the hour, but I'm not surprised. I've got new questions down the bottom. Hold on. Hold on, let's go down there. Got someone who changed locks, won't allow the workman to enter the room for an annual gas check. At the moment, the only way of coping that with Section 21. This will be an interesting one, actually. So Mark, you've got someone that won't allow a workman in to do the annual gas check. I know in Scotland that the gas engineer can force their way in, but they can't in England. So do you think that would be a reason to be able to evict?
So as it stands, you'd have to apply to court for what's known as a gas injunction or electricity injunction if needed, which again has its own host of issues and delays in court processes. I believe there is a ground, even as it stands now, in respect of that, but it wouldn't apply under antisocial behaviour. But I have to just go back through. But I believe there is a ground.
There's a ground if they're not fulfilling their contract, but it's discretionary, and you'd have to make a really good case in court on that one.
Indeed, yeah. So I think like a lot of these things, probably, but again, you probably have to get it past the judge at the end of the day. Yeah.
So again, we wait to see on this one. Someone's asked about does it impact rent a room where the landlord lives? My knowledge is no, because this is basically about what were ASTs. It's not covering licenses, which is where you get a landlord living in the property. At the moment, it's not covering licenses, but there was some mumbling about the possibility of bringing licenses into a similar situation. But I really can't see that happening in this parliament, quite frankly. Mark, what's your comment on licenses?
The point is, most of the time when landlords think they're entering into a license, it quite often becomes an AST in any event. And assured short-hold tenancy is not, if you sign a document that says assured short-hold tenancy on it, it is implied by law or imposed by law. If the tenant has, for a certain period of time, occupation of either the full part of the premises or a significant defined part of the premises, at rent in excess, I think it's £100 a year or something similar. So if there is that arrangement, that's an assured short-hold tenancy as it stands. Now that would then become a periodic tenancy under the current proposal, assured tenancy, but on a periodic basis. So again, if you have a lodger in, but you retain use or you live in the premises, then in most cases, even if that's paid for, then it'll still be a license and you can just serve a notice to quit to get them out. But you have to be quite careful about that. If you move out and let them live there for any significant period of time and they have free reign over the entire premises, you want to be careful about that turning into, in essence, an assured tenancy or a periodic tenancy.
Okay, right. Well, hopefully you've all seen the questions. I've mentioned at the start of this that we're recording this when we've edited it, so which won't be tomorrow, but should be Friday. It will be sent out to everyone that's registered on this particular session. We will also be making it available to members through the weekly e-news. We will be keeping members up to date through the weekly e-news. So if you're not getting the weekly e-news, or God forbid you're not a member or an expired member, then do let us know. We, as I've already mentioned, we will be doing a fact sheet. That's it there, more or less finished. That will be put out with the weekly news next Tuesday as well. And we will be keeping you up to date as these things go on. Particularly, we're meeting MPs, I forgot when now, 4 weeks' time, something like that, to discuss it with them. Also, we'll have a Lord there as well, and we will be trying to start to influence people. We'll only be trying to influence people where it matters. And I've already mentioned that, you know, we're fairly happy with a lot of it. We've got no particular problems with the property portal. We've got no particular problems with the Ombudsman. We've got no problems with the Decent Home Standard, as vague as it is. But please give us a decent home standard. We've got no particular problems with the Section 8. What we've got the problems is the loss of the Section 21 being able to control antisocial behaviour, and the periodic only tenancies. They're the two main things that we've really got problems with. What we're saying to government is beware of what you wish for, because without the Section 21 and with all tenants, all landlords, in future doing their extreme due diligence, if they've got the slightest concern in the future, then they probably won't offer. Which could mean that unless a prospective tenant gets sort of 11 out of 10 for a referencing and or cannot get correct guarantors, they're not going to get offered. And where they're going to go, local authorities and central government have very little social and council housing. Unfortunately, they're going to end up in bed and breakfast. Which is going to put all the come out of rents and out of rates and taxes, etc. So let's call it a day at that. If you've got any more questions you wish to send them to me, please do send them through. Mark, thank you so much for that, being as useful as always. So, you know, hopefully people found that useful and interesting, and, you know, we'll pick it up in the future. So, Mark, thank you so much.
Thanks, Peter, for having me.
You're more than welcome. Thank you all in one. See you the next time.